A three-judge bench of the Supreme Court has stayed the operations of the Social and Educationally Backward Classes Act 2018, which granted Maratha quota, and has referred the issue to a constitution bench of 5 judges or more than final adjudications. The bench, comprising of Justices Nageswara Rao, Hemant Gupta and S. Ravindra Bhat, further held that no appointments or admissions shall be made under the impugned Act for the year 2020-21. However, the postgraduate admission that has taken place till date shall remain unaltered. The Supreme Court referred to a larger bench a batch of petitions challenging the Maharashtra State Reservation for Socially and Educationally Backward Classes Act, which provides for reservation in employment and education to the Maratha community. The bench of Justices Nageswara Rao, Hemant Gupta and S. Ravindra Bhat has held that in the meanwhile, there will be no such reservation in jobs and admissions. The court had further ruled that admissions to postgraduate courses will not be altered. The matter will now be placed for Chief Justice of India, S.A. Bobde, who will constitute a larger bench. The bench had heard the parties on the questions of reference of the matter to an 11-judge constitution bench on the issue of 50% cap on reservation. Senior advocate Mukul Rohadgi, representing the state of Maharashtra, the senior advocate Kapil Sibal, representing an applicant, urged the court to refer the issue of the 50% ceiling on the reservations to a larger bench. The SCBC Act provides for reservation for the Maratha community in the state for Maharashtra. The decision of the Bombay High Court upholding the law with modifications was challenged before the Supreme Court. One of the primary grounds for challenge was that this law, if implemented, would breach the 50% upper ceiling in place for reservations. With the change in the demographics of society, there is a need for the upper ceiling to be revised. The senior counsels in support of the SCBC Act had argued. It was further argued that this case needed to be examined by a bench of 11 judges, considering that the judgment delivered in the Indra Soni case was delivered by a 9-judge bench. Counsel in favor of making the reference to a constitution bench had argued that after the 103rd Amendment providing for the EWS reservations, the ceiling fixed at 50% was breached in almost all states. It was pointed out to the court that in the Janhit Abhiyan case, the challenge to the constitutional amendment providing the EWS reservations has been referred to a constitution bench. Therefore, a statutory enactment like the SCBC Act should also be similarly referred. On the other hand, senior counsel like Arvind Dattar and Gopal Shankar Narayanan, who opposed the reference, argue that if the court decides on the SLP filed and concludes that the Maratha community is not socially and educationally backward and as such not eligible for the reservation in the first place, the questions of breaching 50% is rendered void and the matter may not be needed to be referred at all. It was argued by these lawyers that the matter be heard on merits, and if during the hearing the court is of the opinion that a reference is needed, the same can be done at that later stage. Bureau Report.